Okay, good afternoon. The date is Monday, March 21st, 2022, and I'm Nicholas Chalco. I'm going to give a very short presentation, which I think was pretty interesting. That's why I want to share, on comparative criminology, or specifically comparative criminal justice systems. And we're going to look at the specificity of codification and compare this to, ever so briefly, we'll compare this to Eastern legal formalism. Okay, so let's jump right in. So specifically, we're going to do this by looking at some Colorado state criminal codes. And we're going to compare these to the German criminal codes. I'm going to emphasize how they expect judges to do more comparison or to reason independently based on the individual case. And then we're going to look at some French criminal codes, compare them to the Germans and the Americans, and then finally we'll read through some Chinese criminal codes, and I'll emphasize what the textbook calls shades of normativity, levels of transparency, and degrees of legality. In other words, we're going to see just how vague it is and how they've designed a system that is capable of being applied to you if they want. We'll talk about that in just a second. It's quite interesting. So here we are. Here we are at the American criminal codes. So what the textbook emphasizes over and over again is that Americans really love to spell out exactly what a crime is and what the levels of the crime are and what the criteria for the crime are. And you can see this here, and you're going to understand this a little bit more when we compare these to other criminal codes in other countries. Okay, so here in the state of Colorado, it states at the top, in the first heading, a person commits theft when, okay, it's very direct and very clear. He has to knowingly obtain or exercise control of anything of value. Anything of value, we'll emphasize this, without authorization. And then it breaks it down what it means to do this without authorization, or what it means to take something of value, or the method he could have employed in order to obtain this valuable item, and why it counts as theft according to the criminal law. Okay, so notice the American Criminal Code is very specific. It's gonna get you. Americans like to do this. They're very proud of having very extensive legal codes that explain exactly how and when you break which laws and which criminal statutes. Okay. So compare this to the German criminal codes. Here it says the German criminal code has only two subsections as compared to here, okay? Now, only two subsections, and it says, whoever takes chattels belonging to a property belonging to another away from another with the intention of unlawfully appropriating them for himself or a third person shall be liable to imprisonment of not more than 5 years or fine. So you see here, there's so much latitude. Where's my pen? Let's get a pen here. Okay, hold on just a second. I'll try to make this ever so quick. Okay, here's my pen. Just a moment. Make it a little bigger. All right. So if you notice here, it says not more than 5 years, so you have quite a bit of leeway, and it doesn't state how much the fine is. Again, you have so much leeway. The judge is supposed to use his own logic to apply the code to individual cases. He's supposed to make a judgment. It's the decision of the case rests on his logical deduction, his application of the code to the case. Okay, so let's erase. And notice here it says the attempt shall be punishable. So broad. Okay, but it gets even more broad. Watch in just a second. So here we are, and we go to the next one. Okay, the French are even more vague. Look at this. I'll get my pen again. Here comes my pen. Theft is the fraudulent, and it doesn't explain what it means by fraudulent, appropriation of a thing belonging to another person. End of story. Okay, so this is an example of a general principle. The French have designed a series of criminal codes that are essentially general principles to be applied on a case-by-case basis. Okay, so this is in comparison to the Americans. Just a moment. The Americans who very much they like to know what will happen to them in advance of why. They like to know very clearly how the law is going to be applied to them. And my understanding of history is this is based on a suspicion of power, a deep foreboding of or apprehension of state power, going back to the monarchy of England, okay, and King George. So now we get to the East. Now we're looking at legal informalism, and that is a whole doctorate in itself. It was pretty interesting. I think you'll be able to understand it as we look at the China example here. Japan is interesting as well, but China is even more so. So Japan has some examples of ambiguity, but China is going to show this much more clearly in how they define crime, and really definition of crime is the wrong way to explain this. So look here, it says a crime refers to an act that endangers the sovereignty or the territorial integrity and security of the state, or splits the state, or subverts state power. So notice we're focused on the government here. Okay, of the people's democratic dictatorship. That's hilarious. And it overthrows the socialist system, but we just called it a democratic dictatorship, so that's interesting. Or it undermines public and economic order, so anything relating to money, I suppose. It violates state-owned property. It doesn't clarify what that means. The American codes would very clearly state what this means. Property collectively owned by the working people, blah, 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 infringes on the citizen's rights of person, doesn't explain which rights. And here it just says, or, look at this is hilarious, or other rights. Hilarious. It's so vague as to mean anything, and they could apply it basically when they want. It's too broad, and it's too informal. They've taken their degrees of transparency, I think, to the extreme, really just within a step of North Korea. And then here we end it where it says, whoever steals, we're looking more at this legal informalism and the overly broad laws of East Asia. A relatively large amount, but it doesn't describe what that means. Okay? It also doesn't describe what it means to do something many times. It doesn't describe what it means by a lethal weapon. Okay, where's the other one? It doesn't describe what it means by a fine, how much. Also here, vague, huge, or serious circumstance. All of these things in an American legal system would be clearly defined. Or if the amount is involved in it, especially huge. Here we go again, more overly vague words. Okay, so you get the idea here. This legal informalism, I think, is a little bit dangerous. It's quite interesting to look at the American criminal codes where it's highly specific. And this reflects our culture and our suspicion of power. Whereas the Germans, I think, my understanding is I think they really take a lot of pride in the intellect of the judge, who's supposed to reason through a case. And the French merely write quite broad general principles. Okay, and then the Chinese have a series of, we can barely call them definitions of crime. It's a list essentially of ways you can be punished if they want to. I think they've created a system where they can find a reason to declare you a criminal if they want. And that's our look at comparative criminology, the specificity of codification in the American criminal codes as compared to Eastern legal formalism, where we had an example in Chinese criminal code. Thank you very much.